Hi all, Dr. Waite here. We are in week 5, looking at the lecture material. So in the module, there are two documents for you to click on. This week is on employment laws. That's the theme. The topics we're going to be going over, there's a PDF on gender equity, and then we also have our Chapter 7 PowerPoint, which I have up. So you can download the PowerPoint and follow along with the video, or you can just watch from here. So Chapter 7 is constitutional law is the topic theme here. Some different things that you will know after going through this chapter. Basically looking at the United States Constitution, how it applies to the difference between private and public sport entities, freedom of speech, freedom of religion, how that it protects people and is provided through the First Amendment, how the First Amendment regulates religious prayers and activities in sports settings, which this is really good content for us, especially those of us that are believers, working in Christian institutions, a little bit more open about sharing faith. From what I've learned working in both public and Christian schools, from a public sector, the employee is not, it's frowned upon for the employee to press religious matters in a public setting, especially a school that's supported by the public, or like public law, versus a private institution, especially a Christian institution. You're encouraged to share your faith. However, in a public setting, students and players, athletes, are more than welcome to come to you sharing faith, and then once they engage in that, then you can open up and reciprocate it. So anyways, First Amendment kind of covers those ideas of freedom of speech and protecting individuals. Some different definitions on how this applies to sport organizations, and also the Equal Protection Clause of the Constitution. Again, how it affects sport-related affirmative action plans. So the big thing here for the application is looking at the constitutional law, how it applies to both the federal and state and local governments, and then purely private entities are generally not subject to constitutional claims. So it's like the separation of church and state. So private, like I was saying earlier, private institutions, they are not necessarily subject to the constitutional laws that govern these topics. But the state action must be shown in order to proceed with a claim. So so we're going to look at some different ideas on here. There's some slides that are closed that you can still look through, but aren't part of the presentation itself. So state action, and then understanding the private entities. This one's kind of interesting. So private actors or state actors. So the NCAA is actually its own organization, which does not count as a state actor. And there was a lawsuit that actually highlighted this and put this law into effect. Now, most high school athletic associations are state actors because they're a public. If it's a public school, it's representing the state because it's state supported, state funded. So NCAA institutions are not necessarily the same. However, there are state funded institutions. Like I think of one locally, Fresno State, or CSU. The CSU system, which a lot of you from California are familiar with, that is a state-funded system, along with the UC system, University of California system. So that would be a state actor. Professional sport leagues and teams are not state actors, so those are private organizations. And then the NCAA within public schools is still its own private institution. It's privately run, so it has some different laws that affect it. Regardless of this, the First Amendment basically states that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, of the right of the people peacefully to assemble and to petition the government for a redress of grievances. Says here for religion contains establishment clause and free exercise clause, and then for speech it protects free speech, freedom of the press, and the right to assemble. So basically, the establishment here is that there can be no government established religion, and then the free exercise is that government can't interfere with anyone's right to practice religion. That's what the First Amendment basically stands by. And then there's some different clauses that you can look at here, which are kind of self-explanatory for those. And then establishment clause test. So basically, there is no overriding test to determine whether government acts violate the establishment clause. So the courts have developed 3 different tests. There's a limit test, a coercion test, and an endorsement test. And then there's some slides here that go over each one. So this kind of breaks down the limit test, and then the coercion test, and the endorsement test. Really, the limit test is the one that I kind of highlighted to look at, and there's a case study there. All right, so I'm going to skip down to school prayer. This is an interesting one. So a few topics here just to kind of look through. I'm not going to go in depth on each one. You can read about them. But basically, school prayer, it states that classroom prayer is not permitted. So should be no organized classroom prayer. And this is for the state setting. So at a Christian university, it's fair game. In fact, I often pray before class with students. Especially over a test or something like that. I feel like bringing in prayer helps kind of settle nerves and supports them, especially most students that are attending Christian university are Christians, so they appreciate the prayer. So it says in most cases a non-sectarian and non-proselytizing student-initiated prayer before and after a sport event is a safe haven. So in other words, what this states is, going back to the limit clause, it's stating that students can initiate the prayer, but the employee of the institution cannot. So it says this is hard to establish for school sporting events. Basically, school typically picks student speakers. School can't direct the process that results in prayer, and the prayer must truly be student initiated. It's kind of hard to regulate that, so oftentimes prayer does slip into sporting events, even at public institutions, which is cool. So other First Amendment issues, free speech clause, freedom of the press, probably more familiar with these. Basically, you have the right to speak openly, but obviously it has to be appropriate. And then, so if it's offensive, then it goes into discrimination, right? So there are some checks and balances here with the discrimination laws that we looked at a week ago. And then freedom of the press, kind of the same approach here. Basically, you have the right to say and write what you want, but you still have to be careful what you say and write, because you can still get yourself in trouble if you discriminate against someone. But you have the right to speak up. Commercial speech, again, the right to speak, even politically, is protected in the public. 14th Amendment, this one is the Equal Protection Clause, the EPC. It prohibits the government from denying persons equal protection under law. So everybody has the right to be protected. Everybody is... especially this applies, this really came into effect due to discrimination. So it says here that intermediate scrutiny applies to discriminations based on gender, illegitimacy, alienage. State discrimination must be substantially related to achieving an important governmental interest. And there's a case here, Ledke versus Kuhn, and basically, this was the banning of female reporters from male locker rooms did not survive immediate scrutiny. So kind of interesting cases that were brought up with that. So equal protection, so 2 types of discrimination can lead to EPCs. So 2 different, de jure discrimination and de facto discrimination, 2 different types that led to EPC. And then some different examples of types. So affirmative action is one. due process. So how are things processed through the court? So a course of legal proceedings that have been established for the protection and enforcement of private rights guaranteed by the U.S. Constitution and state constitutions. Fifth Amendment applies to acts of government. No person shall be deprived of life, liberty, and property without due process. So in other words, what this means is everybody has the right to protection. And yeah, so if you are discriminated against, you have the right to protection due to these laws. And so it's kind of interesting. There's like checks and balances here between laws that affect legal proceedings and protect the person, and basically in two different sectors, so the private and the public sector. So kind of interesting. This definitely affects sport, because sport kind of falls outside the lines of most public sectors. So the private sector is where there's more leeway here as far as like prayer and religion goes. But the separation of state and church is kind of interesting how it's defined in the law. So that's kind of the basis of this chapter. Feel free to read through a little bit more of the content referring to the different amendments and how it regulates public and private sector.